you're interested in speaking,
She told me she would be there.
rise for the pledge, please.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you all for coming out. We're going to continue the public hearing for the GCCPDD. I'd like to start with a statement from our attorney, which is the response from Putnam County Planner and Putnam County Planning Department, Barbara Barossa.
Thank you, John.
Thank you.
Yesterday, we received a response from County Planning. It says that it's the proposed local law, as far as the county is concerned, is approved as submitted. They did, however, add a non-binding comment, and the non-binding comment said, please carefully review proposed definition of special events to ensure it captures the town's intent for these activities. So I contacted County Planning and asked what they meant by that. And their concern was that the definition of special events as it's currently written in law provides a special event is an event or gathering of more than 100 spectators related to theatrical events, performances, rehearsals, and cultural events. And as I'm sure you recall, we recently changed the language to add the words, and not listed among the other permitted uses in Section D. And the commissioner pointed out to me that the uses listed in Section D included the open-air theater, as well as the lawns, as well as the gardens. And she said if viewed spatially, instead of as a use, that is to say the lawn is an area instead of the use of a lawn, so too with the gardens, it would encompass anything that happened on the property. And she said you might wind up in a situation where you wouldn't need any special event permits because spatially at least, everything that occurred on the property would be occurring in those areas. Now, I don't think that's the intent of the law, and to be candid with you, I don't think it can be fairly read that way. But county planning is county planning, and in order to avoid any type of misunderstanding as to the limited scope of what's not a special use. The entertainment uses there aren't special uses. The normal passive use of the lawns is not a special use. Normal passive use of the gardens is not a special use. Anything else that happens on the lawns or in the gardens is a special use. You're going to have to come, well, unless it's less than 100 people. Then you have to come to the town and get your special use permit. So what we're proposing to the board is that you just modify slightly as in subsection D. As in